Good morning. My name is Jonathan Adler. I'm an associate professor here at Case Western and also associate director of the Center for Business Law and Regulation. Welcome to our program on eminent domain, urban renewal, and the Constitution. As I think all of you know, in a few short weeks on February 22nd, the Supreme Court will be hearing the case of Kelo versus the City of New London, a case that pits local property owners against the local government, property owners claiming that their land is theirs and shouldn't be taken for economic development, a local government saying that it needs to use the power of eminent domain to take private property to facilitate the redevelopment of the local area. This case, coming out of Connecticut, is one of an increasing number of cases of pitting property owners and local governments over the issue of local eminent domain and when it is and is not justified. Those of us from the Cleveland area are very well aware of these conflicts, given that our suburb of Lakewood was the home of a fairly prominent conflict over eminent domain that was featured on 60 Minutes and elsewhere. And in Michigan, just last year, there was a very prominent case in Wayne County where the Michigan Supreme Court unanimously overturned the decision of Poletown and rejected economic development as a basis for the use of eminent domain. This issue raises important policy and constitutional questions, which we're going to discuss today, initially with a panel on what, if any, constitutional limits are there on the use of eminent domain for economic purposes. What precisely does public use mean in the Fifth Amendment of the Constitution? A second panel on the policy questions of when eminent domain is or is not desirable as an economic policy tool, and then a debate on the merits of the Kelo case, featuring two individuals who are involved. This conference is co-sponsored by the Center for Business Law and Regulation and the Environmental Law and Property Rights Practice Group of the Federalist Society. If I could just say a few brief words on each of these two entities. Center for Business Law and Regulation is directed by my colleague Andy Morris, was established a couple years ago to be a center for the study and discussion of issues relating to both business law and the regulation of business. It sponsors numerous classes, programs, and research efforts. Among its other programs is the annual George Leet Business Symposium. This past October held a symposium on corporate governance. We also host the annual Dean Lindsay Cowan Business Law Lecture. Last year, this lecture featured Nobel laureate economist Vernon Smith. This year, on March 30th, University of Chicago Professor Richard Epstein will be speaking on justified monopoly, focusing on the regulation of the pharmaceutical and telecommunications industries. The center, as I said, also sponsors various programs for students and various classes and other lectures and visitors. This program is also co-sponsored by the Environmental Law and Property Rights Practice Group of the Federalist Society. This is one of 15 practice groups in the Federalist Society's Lawyers Division that sponsors debates and programs where to have an exchange of ideas and points of view on various important public policy issues. If this program interests you, I would certainly recommend that you look at the Federalist Society website and see other programs that they have coming up. I know that in the environmental law area, they have programs scheduled this spring relating to whether or not state efforts to deal with carbon dioxide and greenhouse gas emissions are preempted by the Clean Air Act, as well as a program on the portrayal of business and environmental problems in popular media. And for students, there's also a student division of the Federalist Society, and students here at Case, I think, are familiar with some of the programs they've sponsored here. Quite a few thank yous are in order in terms of making this program possible. Certainly, I'd like to thank the law school and in particular our dean, Jerry Korngold, who sends his regrets and unfortunately is unable to be here today, but he has been very supportive both of the center and of putting this program on. I certainly also would like to thank the Federalist Society and Dean Reuter, who's head of the Lawyers Division there, for their support of this program. We have quite a few student volunteers that have helped out with this program and are helping out today, and they certainly deserve a lot of thanks. A special thanks is also due to Nancy Cantor and Alice Simon, who've been tireless in their efforts to help make this program possible. Our first panel today is going to focus on the constitutional question of public use and what it means. And I have the pleasure of introducing my former property professor, Stephen Eagle, who will moderate this panel. I should just say as a caveat, if any of you feel that I misunderstand parts of property law, the fault is entirely mine and not his. But he is a professor of law at George Mason University School of Law. Among other things, he's the author of the Treatise on Regulatory Takings, and he is the vice chair of the Land Use and Zoning Group of the American Bar Association section of Real Property, Probate, and Trust Law. So without any further ado, I will turn it over to Steve, who will moderate this panel on public use. Thank you and welcome.
Thank you, John. If the downside of being a property professor or any other law school professor is grading exams, the upside is seeing students flourish and doing well. So I'm delighted to be here with John today and with all of you. Eminent domain is the traditional power of the sovereign to take private property for the public good. In the United States, the Constitution does not provide for eminent domain, but rather explicitly recognizes its existence when it says, "Nor shall private property be taken for public use without just compensation." And the focus of our program today is on the meaning of public use. And as those who toil in the miasma that constitutes regulatory takings jurisprudence know, sometimes an issue can rest fairly quiescent for many years and then suddenly burst into renewed public attention. And that's been the case with the public use issue. In 1954, in Berman versus Parker, and in 1984, in Hawaii Housing Authority versus Mitkiff, the Supreme Court issued opinions which were generally understood as giving state and local governments carte blanche to take private property by eminent domain whenever the governmental entities thought it was appropriate. Justice Douglas and Berman declared that once the object is within the authority of Congress, such as alleviation of blight, the right to realize it through the exercise of eminent domain is clear. And in Mitkiff, Justice O'Connor declared that the public use requirement is coterminous with the scope of a sovereign's police powers. So it seemed that the legal import of public use had been settled. But as it sometimes happens, much went on behind the scenes. A 1998 story in the Wall Street Journal for many brought this to light in terms of eminent domain. And the story said, local and state governments are now using their awesome powers of condemnation or eminent domain in a kind of corporate triage, grabbing property from one private business to give to another, a device used for centuries to smooth the way for public works, such as roads, and later to ease urban blight, has become a marketing tool for governments seeking to lure bigger businesses. And from that followed some well-publicized cases involving situations where the eminent domain power was pretty openly put up for sale and where it was used in a pretextual way to allow one competitor to grab another competitor's location. And as John mentioned, the issue came to a head for many in the County of Wayne versus Hathcock case last year in Michigan, where the state's famous Poll Town decision was overruled, and you'll be hearing a fair amount about Poll Town during this session. The Supreme Court will be hearing the Kelo case later this month, and this issue now is really foursquare in the public attention and in the attention of lawyers and scholars in this area. To discuss the legal implications of the public use issue, we have four distinguished experts with us today. To save time, I'll introduce them all now in the order in which they'll speak. Thomas E. Merrill joined the Columbia Law School faculty in 2003 as Charles Keller Beekman Professor. He previously taught for over 20 years at Northwestern University Law School and served as a Deputy Solicitor General in the Department of Justice. Tom graduated from Grinnell College, was a Rhodes Scholar at Oxford, and has a law degree from the University of Chicago. He clerked for D.C. Circuit Chief Judge David Bazelon and for Supreme Court Justice Harry Blackmun. Tom is the author of The Economics of Public Use, which was published in the Cornell Law Review in 1986, and I think is one of the seminal pieces in this area, and also Property Takings, which was published in 2002 with David Dana. He has filed an amicus brief supporting the city in Keeler versus New London on behalf of the American Planning Association. Our second speaker, Eric Claeys, is an assistant professor of law at St. Louis University. He has written extensively on American natural rights theory as it relates to property and land use law. He's published in Takings, Regulations, and Natural Property Rights in the Cornell Law Review in 2003, on the Euclid decision, and he has a forthcoming piece on public use limitations and natural property rights, which will come out this year in the Michigan State Law Review, and on which his comments here today are based. The third speaker, John Mogk, is a professor of law at Wayne State University in Detroit, where he specializes in urban and regional development, housing, property, land use, the environment, energy, and corporate issues. His undergraduate and law degrees are from the University of Michigan, and he has a diploma in comparative law from the University of Stockholm. John has served as a consultant on various urban issues to, among others, the city of Detroit and the state of Michigan. Our last speaker, Timothy Sandefur, is a staff attorney for the Pacific Legal Foundation and almost ubiquitous advocate for owners and property rights cases. Tim's work in eminent domain include amicus briefs in Kelo and on behalf of the ACLU Fund of Michigan as well as PLF in the Hadcock case. His articles on eminent domain have appeared in the Southwestern University Law Review, the current issue of Liberty Magazine, and a forthcoming issue of the Harvard Journal of Law and Public Policy. Before joining PLF, he clerked at the Institute for Justice and the Claremont Institute. Tim is a graduate of Hillsdale College and Chapman University School of Law. Our speakers' presentations are going to be briefer than we would like, so that we will have time to have discussions amongst the panel and perhaps the most important part of a program like this one, to entertain questions from the audience and from those who are listening on the webcast. With that, I'll present the first panelist, Tom Merrill.
Thanks very much, Steve. It's a great pleasure to be here and a great pleasure to be able to engage with you on the question of what should be the scope and limits on the power of eminent domain. Steve was gracious enough to offer me a couple extra minutes of time, but on the strict condition that I forego any editorializing on the subject before us today. So I will do my best to offer a kind of setup of some of the background to the constitutional issue pertaining to the public use limitation on eminent domain, and try to keep my editorializing to my implicit inflections and selection of materials rather than explicit statements, at least in my presentation. So the first thing I want to talk about very briefly is the original understanding of the Takings Clause, and particularly of the public use language in the Takings Clause. Original understanding is not discussed very much in the briefs in the Kelo case, but it's something of interest at meetings sponsored or co-sponsored by the Federalist Society, and I think it's appropriate to talk about it as part of the background. Now, the Constitution says, "Nor shall private property be taken for public use without just compensation." There's no comma, although many versions of the Constitution stick a comma in after public use. It's clear from the language chosen that for public use is a limitation on the word taking or taken. So quite clearly the Takings Clause is talking about a subset of takings, not all takings. And so we know that much from the grammar of the clause. But it's unclear, it's ambiguous from the language, exactly what the nature of the restriction on taken is. It could refer simply to the character of the taking, so that for taken for public use refers to a taking of specific property rights by public authority, as opposed to, say, a taking by an accident or a tort, or a taking that takes place because public authority has imposed a fine or a tax on someone and they have to liquidate some of their assets in order to pay that off. So it could just simply be descriptive, in which case the takings clause roughly means, nor shall private property be taken for eminent domain without just compensation. On the other hand, it could also be a reference to the ends for which the property is being taken, to wit, they have properties taken for public as opposed to private ends. And under this interpretation, for public use would be an implied limitation on the power of eminent domain. It could not be used for private use as opposed to public use. We can tease the language a little bit and try to make some judgments about which was more probably the understanding in the minds of the framers that adopted the Fifth Amendment. But probably we won't get too far. A number of commentators going back to the 19th century have pointed out that if public use was supposed to be a limitation on the power of eminent domain, it's rather odd that it was placed before rather than after the word without. Clearly, the takings clause imposes a limitation on eminent domain insofar as you can't take property without just compensation. But if the framers had intended there also to be a limitation that you could not take property without public use, they should have put without before public use and just compensation rather than putting without just before just compensation. On the other hand, if it's just descriptive, it's a little bit odd that the framers chose the words for public use as opposed to by public authority or something of that nature. And so I think the language is not terribly decisive one way or the other. The legislative history of the takings clause is basically non-existent. James Madison was the person who came up with the idea of a takings clause. None of the states that were insisting on provisions being added to the Constitution in the form of the Bill of Rights wanted a takings clause. On the other hand, once Madison came up with a takings clause, nobody objected. The attitude seems to have been, oh, well, we didn't think of that, but yeah, that sounds right. Property shouldn't be taken except for public use except for just compensation. So there's no debate about the takings clause in either the recorded debates in the House of Representatives on the Bill of Rights or in the various ratification conventions that occurred thereafter. I think probably the best evidence, or the evidence that would be the most probative, would be to consider what the sort of legal theorists that were familiar with the framers of the Constitution might have thought about eminent domain or takings of property. And here we see a split in the authorities that more or less parallels the split in the way in which the language might be interpreted. On the one hand, you have the English authorities, John Locke and William Blackstone. And they have little squibs on what we now call eminent domain. They didn't use the word eminent domain, but they basically, their take on it is that private property cannot be taken without the consent of the property owner, period. But then they acknowledge that, well, private property can be taken if the property owner consents through their representation in the legislature. And so both Locke and Blackstone seem to believe that the restriction on eminent domain is that the taking has to be approved by the legislature, acting as the virtual representative or as the effective representative of the private property owner. There's no language in Locke and Blackstone about limits on the ends to which taken property can be devoted. In contrast, the continental theorists, Pufendorf, Grotius, and Vattel, that write about natural rights theory and were familiar to some degree to the framers, do use the word eminent domain, and they do explicitly recognize that there are limits to which eminent domain can be used. They had a disagreement about what those limits were. Pufendorf was the kind of liberal of his day who thought that eminent domain could be used for broad public purposes, for example, acquiring land for universities or churches. And Grotius was more restrictive, who thought that property could only be taken for strict public necessity, for example, when a road had been blocked and you needed to develop a detour through somebody's private property. But in any event, the understanding that eminent domain is a limitation was common in their writings. We have no idea which was more influential with the framers. My own guess would be that since Locke and Blackstone wrote in English and were somewhat more familiar to the framers than the continental theorists who had not been translated at that time, that the Locke-Blackstone tradition is the more probable one, which would mean that the framers probably understood the power of eminent domain to be subject to the restriction that it has to be authorized by the legislature, but that there not be restrictions on the ends to which the power be devoted in the form of some kind of public use limitation. So that's basically what we know about the original understanding. What about the early history of the power of eminent domain up to sort of Berman versus Parker? This is rather interesting. The first thing you need to know is that the power of eminent domain was not exercised by the federal government at all until 1875. As Steve pointed out, the Constitution's takings clause seems to acknowledge, by creating a limitation on takings on eminent domain, seems to acknowledge that there might be a federal power there, but people were very uncertain about that, and so when the federal government needed to take property for some purpose, which was rare, because the federal government was rather small in the early 19th century, they would ask the state where the property was located to do the condemnation and then retransfer it to the federal government. So there's no early history of Supreme Court jurisprudence on what public use might mean. In the early period after the ratification of the Constitution, there's also no state constitutional authority on public use. The states didn't use eminent domain very much because land was plentiful and there wasn't not that much need to take property, but there's evidence that property was taken for rather broad purposes. There, for example, a number of states engaged in eminent domain to take roads that would provide private access to landlocked properties. That was thought to be permissible in some states. And quite a few states adopted mill acts, which allowed people to dam up rivers, even if that had the effect of flooding upstream property owners, thereby sort of taking their property. And the mill acts required the payment of just compensation. Many of these mill acts were for grist mills, which were sort of public in nature, but some of them were also manufacturing mills. And so authorized, in effect, private takings of property. It was not until really 1837, Eric may know more about this than I do, but I think the first sort of prominent judicial statement that there might be limits on the power of eminent domain comes in a case called Bloodgood versus Mohawk and Hudson Railroad in 1837, where Senator Tracy from New York Court of Appeals offered an analysis that said that it's unconstitutional as a matter of sort of natural right or justice for the government to take property and give it to another private entity. And Senator Tracy thought that eminent domain could only be used when the government would take title and ownership to the property after the taking was completed. As far as I'm aware, he was the only one that ever took that hardline position, but his opinion was very influential, and it started a sort of slow snowballing process whereby state Supreme Courts gradually began to assert limitations on the ends to which eminent domain could be put. And the dominant theory that these state courts used during this period from roughly the 1840s on was that eminent domain could only be used when the property would be used by the public. It was almost a play on the words, public use, used by the public. And so this became known as the literal test, which was that if the property was taken by eminent domain, it had to be open and accessible as a matter of right to the public. Now this allowed some fairly broad delegations of the power of eminent domain. Turnpike companies, canal companies, and railroads could all use eminent domain to take property because they were common carriers and their property was open to the public as a matter of right. But presumably a manufacturing company, for example, could not take property because its facilities would not be open to the public and hence used by the public. As the 19th century wore on, the use by the public test, which was not ever unanimously endorsed by state courts, but was sort of perhaps by a majority at one point in time, became increasingly convoluted as cases arose about, well, what about private railroad spurs to a particular plant? Or what about irrigation ditches? Or what about mining operations where some kind of eminent domain is needed in order to facilitate the construction of a mine? And the courts began making various convoluted doctrinal amendments to the use by the public test. The use by the public test finally collapsed in the 1930s in the Depression. The event that led to its demise, interestingly enough, was the National Industrial Recovery Act. It's the same statute that gave us the Blue Eagle Codes and the Schechter Poultry case that you may have studied in constitutional law. The National Industrial Recovery Act also provided for federal grants to state and local governments to build public housing, and the states took this money and frequently used eminent domain to acquire sites for the construction of public housing. And in the context of the 1930s, every state court that considered whether this was a permissible public use said, yes, we want the money, so yes, this is a public use. And the use by the public test collapsed in response to that development. Okay, I have to hurry here. What about the U.S. Supreme Court? Now, the U.S. Supreme Court doesn't get into the picture until 1893 because there's no takings by the federal government. And, of course, the Barron versus Baltimore says the Fifth Amendment didn't originally apply to the states. It did after eventually the courts in late 1890s said it did through the 14th Amendment. The U.S. Supreme Court, I have not done an exact count. I think it's roughly in the ballpark of 25 Supreme Court opinions from 1893 to the present that have some significant discussion of the public use limitation in them. Most of these are federal takings cases. A few would be, well, maybe 50-50 federal and review of state takings under the 14th Amendment. Throughout that period of time, there's been only one invalidation for lack of a public use. This is Missouri Pacific Railroad versus Nebraska in 1896. That was a case where Nebraska simply ordered a railroad company to transfer property to a group of farmers to operate a grain elevator on railroad property. The board, the Transportation Board of Missouri, thought they had the authority to do this based on their control over the railroad under its state charter, so they didn't bother to use eminent domain. They didn't bother to assert any public justification whatsoever. They just ordered the railroad to do it. The Supreme Court said you can't do that. That's a transfer of A to B, a property from A to B without any justification whatsoever, violates the Due Process Clause. Other than that, the Supreme Court has affirmed in every single case involving some contest over public use. These affirmances include, one thing that's significant is the court was never tempted by the use by the public test. Even though the state courts had adopted this in maybe half the states, the Supreme Court rejects it in the in the 1890s and never is tempted by it. A number of these cases involve retransfers of property, including Berman and Midkiff. And a number of these cases, 4 by my count at least, in the early 20th century involved condemnations for economic development. Now, these were cases that involved economic development in the sense of taking natural resources like farm fields or mines and making them more valuable by using eminent domain to make them accessible to the outside world. But there was no public access to the property taken. There was no other broad purpose being served by eminent domain other than economic growth. So the Supreme Court case law, I think, is very unappealing for the case that the Kelo petitioners are trying to make in the current case. That's not an editorial comment, I don't think. I think that's descriptive. The last thing I want to mention very quickly is to say something about what the case law, other than the Supreme Court case law, looks like in the period since Berman versus Parker. What does the last 50 years of case law look like in the federal courts of appeals and the state appellate courts? My 86 article that Steve was nice enough to mention did a survey up to 1986. A young fellow named Corey Wilk has done a survey from 86 to 2003. Put these two together, we have 544 appellate decisions involving the meaning of public use during that time period, 31 federal, 513 state appellate decisions. Of the federal decisions, 30 uphold a taking as being for public use, 1 invalidates a taking, and that is largely based on Indiana state law. So the federal courts, extremely deferential to public use findings. Of the 513 state court decisions, 83% uphold a taking as being for public use, 17% invalidate. This is quite striking. 1 out of 6 state appellate court decisions finds that a challenged taking is not for a public use. So the state courts have not completely abdicated a review of public use issue. Typically under the state constitution, although the federal courts are extraordinarily deferential, and some of the cases that we'll be talking about that arise at the state court level, including, of course, Hathcock, are examples of state courts using their state constitutions to continue to monitor this issue. I'm out of time. Thank you.
Thank you, Tom. Our next speaker is Eric Claeys.
Thank you for having me here, and I'm especially grateful to Tom for laying a lot of groundwork that allows me to focus on one slice of the issue and not have to go through a lot of the basics. I'm going to focus on the ways in which natural law and natural rights and social compact ideas would inform how the law of public use might look. As Tom explained, a lot of the background evidence we have about public use clauses comes from legal theorists from the 17th and 18th centuries. And so if you study their writings through, you get a better sense, a richer sense of how public use law might look. I also note that a lot of state constitutions are shot through with commitments to natural rights. I live in Missouri, and Missouri has a takings clause that reads that private property shall not be taken or damaged for public use without just compensation. And that comes 24 sections after a preamble section saying that all constitutional government is intended to promote the general welfare of the people, that all persons have a natural right to life, liberty, the pursuit of happiness, and enjoyment and the gains of their own industry. So if you know that a state constitution has that kind of declaration, you ought to think maybe the takings clause and the public use clause in that state ought to be read in pari materia with those kinds of preambles. And so you have a need to know, how do natural rights or social compact ideas inform a takings clause and a public use limitation? And my basic point that I'll give you is this, that if you think that this natural rights theory has enough content, it gives you two lessons. One is that public use law, in the simplest and most direct form, is pretty straightforward. It's the narrow view of public use to which Tom referred. The public must use the property. Natural rights ideas, though, say that there's another side to the kinds of cases in which the government condemns a fee. And that's harder, and that's a regulatory taking side. So what we would now call a public use case has a public use issue and a regulatory takings component. And I want to flesh out in the rest of my remarks what I mean by that. So what I'll do is to try to sketch out at 30,000 feet what natural rights ideas add to the analysis and the justifications for takings. Then explain the basic doctrine that applies those general ideas. Then I'll try to apply that to some of the most important and recurring disputes in contemporary eminent domain law. And finally close with some of the insights you get on the level of policy from the natural rights ideas. So let me start with the basic natural right justification for property and for eminent domain. In the natural rights view, property is a manifestation or a recognition of two tendencies or two insights about people. On one hand, people are all similar. They all have a natural propensity to work, to do active things, to be selfish, to be productive. We all have a tendency to try to do things for our own chosen purposes that are active to advance those purposes. The natural right to property takes its character, though, from another recognition, that by nature people are all different. They have different talents. They come from different situations in life. They have different tastes or desires. And from that, what you then end up with in the writings of Blackstone, Locke, and then American natural law jurists is a claim that property ought to protect in each person a zone of freedom within which to choose how to use and apply one's own active passions to one's own distinct and unique talents and distinct and unique ends. And so what you want is a right of property that is as broad as can be, with the equal rights of others to have the same control, make the same policy choices about their own property. What you then end up with is that conception of property then fashions conceptions of regulations and takings. A regulation is a law that makes property regular in this understanding. It defines in the actual code of law the substance of what the natural property right ought to look like in positive law. It protects that right. Think of a trespass law. A trespass law says all of us have a right to be secure that we can keep the occupancy of our own land from people entrenching on it by squatting on our land. And so a trespass law defines the natural right to property and gives somebody real-life protection against it. Some regulations then go on beyond defining the right to property and protecting it from invasions. They can reorder rights in a way that enlarges the rights of all people affected. And a nice example here is a conveyancing law, like a statute of frauds. You could say that a statute of frauds and a title law and other similar laws restrain property rights. When my wife and I bought our house, we had to pay a not inconsiderable amount of money to the local registrar of deeds, to a title company, to a survey company, and you could say that all of those costs and requirements are restraints on our freedom. But what we bought with all of those requirements was a much clearer set of securities that the land we were buying was the land we were getting and nobody else owned it. And so the security we get so outweighed the costs that we went through the title and the conveyancing process that it enlarged and made more secure our property rights. So those are regulations. Takings, then, are actions by the government that restrain these broad zones of property more than is necessary for the general objects of regulation. And anything that you can't justify or pass muster as a regulation becomes a taking. So let me move to the next part and ask then how, when the government condemns land from somebody, how do public use and regulatory takings ideas fit in? And basically, you end up with the first question you ask is, can the condemnation be justified as a regulatory taking? And here what you have is the law ought to inquire into some kind of means and scrutiny, and the kind that I think is most applicable for current law is the law of exactions that you see from cases like Nolan versus California Coastal Commission and Dolan versus City of Tigard. In these cases, the courts ask, what is the government's justification for acting, and does it have evidentiary proof to support that justification? The natural rights inquiry, though, is a little bit narrower than Dolan and Nolan in that it asks, is the government acting to protect property rights, or is it acting to encourage the free exercise of property? See, there has to be a connection between the government means of condemning and one of those two ends. If the government action cannot be justified on that ground, then it's a taking of property. And then you have to ask, is the taking for a public use? And the public use, again here, it's a narrow view of public use. The government can insist that people cede their property, but the government can only do so in principle in those cases where the public is in fact going to use the property, either directly, in the case of the public takes property for a library or a courthouse, or by delegation when the property goes to a common carrier regulated by the government. And if the property is not taken for one of those, by either a common carrier or by the public, then it's a taking for private use and is then unconstitutional. And I'm happy to go through some of the sources that support this, but I'll save that for questions and answers. I just would note that there are sources from earlier than the 1830s and the 1840s, from what Tom was talking about, suggesting that American jurists were quite hostile to the idea that a public necessity can justify a private transfer of property. That goes back, the earliest site I found is from 1795. But what I'd like to finish out with is to just give you some illustrations of how this conception applies to some of the kinds of condemnations you see most often in practice now. One example occurs when a city condemns land and transfers it to a developer, to a business, on the ground that the land condemned is blighted. It's been neglected, there's graffiti on the property, broken windows, and take those and other evidence of disrepair together, and it suggests that the property is not being taken very well care of, and it would be better if somebody else were to take the property over and manage it more actively. It is possible that blight laws could be regulations of property. But to prove that, you need to prove that, or the city must prove, that the property is in fact in a state of neglect. And so a sound natural rights approach would ask, say, of the city of Lakewood, nearby here, if the city defines a house to be blighted if it doesn't have a two-car garage and 2 bedrooms, is that really a bona fide definition of blight or not? And if it's not, then the regulation is condemning land, taking property rights more than is necessary. If the government can, however, show that there is evidence of crime or broken windows or graffiti or other kinds of problems, the government can punish the owner or coerce the owner to improve the property. But even so, under a means-ends analysis, you'd have to ask, does the government need to take the property away lock, stock, and barrel? Or can it take lesser steps of, say, fining the person or ordering him, enjoining him to improve the property without forcing the property to be taken away? If the government cannot make that showing, then again, it's taking more property rights, restraining more property rights, more than is necessary for regulation, and is therefore taking the property. So if a blight condemnation restrains more than is necessary for regulation, it's a taking, and then you need to ask, does the government keep the property, or does it transfer the property to a private party? And if the property goes to a private party, under natural rights principles, that's a taking for private use and not public use, and it's unconstitutional. Another area that occurs when the government takes property for the grounds of promoting general economic development. And here, it is possible, there are some cases like the Mill Acts that are problematic and can be justified on the grounds that the property owners who are ousted get a reciprocity of advantage, but something it takes longer to explain than I have time to do here. In most economic development cases that occur today, governments cannot say that the owner who's refusing to sell out is harming anybody, threatening anybody, so there's no general ground for proper regulation. And so again, you need to ask, is the property being taken for public use or private use? And if the property goes to a developer, if it goes to a business, it's a taking that's not a common carrier, it's a taking for private use and is unconstitutional. Now, the natural rights approach is important for a couple of different reasons. It is one part, though by no means the only part of the story if you're interested in understanding what public use limitations mean as a matter of original meaning. At a level of policy, what it's suggesting is 2 points that are different from a lot of the discussion about public use law now. One is that the natural rights approach claims that the object of government is not to do things like to create jobs or to promote the tax base. The ultimate job of the government is to secure freedom. And if the government dislocates the freedom of a few people for the general benefit of everybody, it's acting in ways that don't justify anybody owing their allegiance back to the government. Separately, the understanding of property that's manifested in it is claims that people have a lot of active talents and a lot of peculiar talents. And if you let the government kick people off their properties without a compelling justification, you discourage them, you render them less secure that they're going to be able to use their own for their own purposes. And so what you end up with is a few short-term economic gains, but a long-term demoralization of the community. And so if governments actively go for promoting economic development, they'll create some jobs in one part of town, but what will happen is there'll be a lot of neglect of property all around, and they won't be able to explain why. And so that's the challenge that the natural rights approach allows for contemporary practice. Thanks.
Thank you, Eric. Our next speaker is John Mogk.
Thank you, Steve, and I'd like to thank the Federalist Society and the Case Western for including me in this panel, as distinguished group of panelists, and I'm learning as we go here. I think perhaps my contribution to the discussion today is to focus on the Michigan situation, the Poletown case, and Hathcock. As Tom pointed out in his excellent brief summary of eminent domain law at the federal and state level, the Berman case was decided by the Supreme Court in 1954, which essentially recognized the appropriate use of the power to condemn and assemble a blighted area in Washington, D.C. for purposes of reconveyancing of the land to private interests for private development. And basically viewed the term public use as used in the U.S. Constitution as one that included public benefit and public purpose as defined by the Congress or at the state level by a state legislature. The Midkiff follows in 1983 where Berman, as Tom pointed out, is confirmed, and essentially Justice Sandra Day O'Connor states that the power of eminent domain is coterminous in its breadth with the police power or the power to regulate. Now, between these two cases, the Poletown case arose in Michigan in 1981, and I have provided, and it's been distributed to you, an article from the Detroit News, I believe, on the 30th anniversary of Poletown. I couldn't exactly fit the date that is the most objective discussion, in my opinion, of the cases, of the facts as they existed in the case at the time. Frequently, we'll see in the legal scholarship citations to various studies that have been performed, most of which, in my judgment, have been highly biased or tilted in their presentation of the facts. And in some cases, they have actually demonized all those who were connected with the project, and that would include the governor, the state legislature, the mayor, the city council, the Archdiocese of Detroit, and the UAW, along with the local media. All of them end up on the short end of criticism by some of these pieces that have described the project. In the case of Poletown, there was the General Motors made a decision to close 2 manufacturing plants built about around the time of World War I. These plants, as with all other manufacturing plants in the city, were built multi-story, 3 and 4 stories in height, and neighborhoods tucked in around them as the city filled out. And most of the workers either could get to their jobs by public transportation or by foot. These became antiquated. There was a need to replace them in the late 1970s, and General Motors decided to close 2 in southwest Detroit, and 6,000 jobs were at risk. Now, at this particular time in the late 1970s, the city of Detroit had already turned the corner. It was already losing thousands of jobs, and people were moving out. It was beginning to decline in a very significant way. The then popular elected first African-American mayor wanted to attempt to do something to try to turn around this process. So he essentially convinced the chairman of General Motors to consider Detroit as the location for the construction of a new replacement plant. Now, at that time, the city of Detroit didn't have 40 acres, contiguous acres assembled anywhere. And in order to build a manufacturing plant, you really need to have it on the major infrastructure components. You need to have it on a rail line, an interstate highway. You need to have it on a major sewer and water interceptor area and a major electric power grid. General Motors, in fact, and I just had a recent discussion with the folks at GM to confirm my views that I developed at the time, was not interested in building in the city of Detroit. They already had selected several sites outside of the city and outside of the state, in fact, which were candidates for this plant. They were moving to a new technology in their manufacturing to compete with the Japanese technology that was causing them to lose manufacturing jobs and sales. And so their plant footprint required 400 plus acres. To make a long story short, they were unwilling to bend. They were unwilling to do anything that would adversely affect, in their judgment, the efficiency and the profitability of the footprint design which they had arrived at and were about to use in several other locations. So they gave a mandate to the city that they would be willing, General Motors would be willing to consider building in Detroit, or would commit and enter into a development agreement to build the plant in Detroit to replace the 2 that were closing if the footprint could be accommodated. And accordingly, the city looked around and selected, with the city of Hamtramck, which happens to be surrounded by Detroit, a city of about 15,000 people, about 1 square mile in size. They agreed that the footprint that was selected would be the one that the city of Detroit would acquire. Now, in order to acquire the footprint, the city had to operate under the Economic Development Corporation Act that was passed by the state legislature several years earlier. It was also necessary for the state and the governor to support the passage of a new Condemnation Act that would allow for the quick taking and assembly of land, called Act 86. Under Act 86, property owners are entitled to receive not only just compensation for their land, but they're also entitled to receive, in addition, all of the legal fees that are involved in an attorney representing them to be certain that they do receive just compensation. There's no percentage of the award. It's taken out of the condemnation. In any event, the process proceeded and it was challenged on the basis of whether or not the state of Michigan's Constitution, which basically says, in language somewhat similar to the U.S. Constitution, private property shall not be taken for public use without just compensation, therefore being first made or secured in the manner presented by law. That's the state constitution. It's Article 10, Section 2. It's also the provision that was under consideration or review in the Hathcock case. The Supreme Court, a majority of the court in 1981, addressing this question as it related to this particular project, concluded that, 5 more minutes ago, concluded that the Economic Development Corporation Act, which declared that it was a proper public purpose to retain industry, retain jobs, and develop create jobs, that act was under the state constitution, was a proper use of the power of eminent domain. That they relied heavily on the Berman case, decided, of course, in 1954. They deferred to the legislative determination of what a public purpose is, but they took one step further in their decision in the Poletown case. They basically said that when the action of the city, in this case, benefits specific and identifiable private interests, a court inspects with heightened scrutiny the claim that the public interest is the predominant interest. In other words, they employed a heightened scrutiny test in Poletown, unlike any discussion of such a test in Berman versus Parker. Having employed that test in Poletown, they found, as a matter of fact, that the benefit to General Motors in terms of this project was only incidental. I invite you to read the Poletown case. There was only incidental benefit. In fact, there was no empirical evidence whatsoever in the case that General Motors profited by building this plant, any more than they would have profited by building it anywhere else. The area that was, very briefly, the area that was involved was an area that was built around or before the First World War. You can see one of the homes that are still standing here by one of those neighbors who opposed the project. And understandably, change is tough on people. Homes that were built during this period were built without a building code. Therefore, there was no building code, and most of them were already suffering significantly from use and deterioration, many of them. Today, there are very few homes, a very small percentage, 10 or 15% of the homes, built during this period that this neighborhood was built to remain anywhere in the city of Detroit. This city's 138.7 square miles. This is on 400 acres. They all basically have been deteriorated and abandoned, and they're all removed. Now, those on the site received an average of $13,000. I, by the way, have made available the article to you to read. They also were entitled up to an additional $15,000 in federal relocation grants, which most of them received. The long and the short of this is that most of the people received twice the compensation they would for their property if it had been a negotiated sale had been possible. Because there were almost 2,000 parcels of land that had to be assembled, between 1,500 and 2,000. To do this in a timely fashion and be able to retain General Motors on the schedule that they needed to meet in their judgment would have been impossible to negotiate it parcel by parcel. The next thing, the next major case is the one that was referred to, the Hathcock case. Whereas Detroit had an unemployment rate of 15% plus in 1980, in the late 1970s, early 80s, when this Poletown case occurred, in Hathcock we have a situation that was not in the city. It was in the western Wayne County around a newly expanded airport. And the Wayne County decided that it wanted to have an industrial park, the Aerospace or Aero Pinnacle Park, 1,300 acres. They privately assembled 1,000 acres. They needed 300 more acres, largely open and vacant land. They decided to use the Economic Development Corporation Act and the power of eminent domain. And so that represents the case. There were 47 or so parcels that needed to be assembled. And the Supreme Court basically held that, overruling the Poletown decision, that economic development was not a proper basis for the use of the power because it was circumscribed by the words public use rather than public purpose. And the public use is to be defined by what experts in the law believed it to mean at the time that the state constitution was adopted, was revised in 1963. It wasn't to be determined by the legislature. It wasn't to be determined by the people who adopted the Constitution, but by those who were expert in the law in 1963. Since no member of the court was in law school in 1963, they could not have been using their own opinions. Since they didn't seem to confer with anybody who was involved in drafting the Constitution in 1963, they couldn't have seemed to have used those opinions. And so what they used was essentially a review of cases in Michigan leading up to the 1963 Constitution. And they rejected the notion that Berman versus Parker should be considered at all as part of that deliberation. Time's up, so I'll answer any questions you may have thereafter.
Thank you, John. Our last speaker is Tim Sandifer.
Thank you. Professor Claeys has given us an excellent introduction to the natural rights concepts embodied in the public use requirements, so I'll just really briefly sum that up and talk about what we have to face to return to a proper jurisprudence of public use. According to the political philosophy of the American founding, which is the Lockean view, government exists to protect the weak from the strong. In a state of nature without government, those who are unable to defend themselves will have the fruits of their earnings stolen by those who are more skilled at combat. So people come together to create a government and live their lives under law, a moral order governing the use of force. Vigilantism is replaced by the police, which protect people equally and punish wrongdoing. Now the problem is that some people are more clever or more popular than others, and so they're able to gain control over the apparatus of government and use it to their own advantage. John Locke believed that this was wrong because the state is limited by the same moral rules that apply to individuals. Since you don't have the right to go out and steal something from somebody, you don't have the right to tell the government to do that for you. Government's power should be employed to benefit for generally public reasons, legitimate public reasons, and not for the private aggrandizement of politically powerful people. From this perspective, James Madison explained the issue that lies at the heart of the public use requirement when he said, quote, "There is no maxim, in my opinion, which is more liable to be misapplied than the current one that the interest of the majority is the political standard of right and wrong. Taking the word interest as synonymous with ultimate happiness, in which sense it is qualified with every necessary moral ingredient. The proposition is no doubt true, but taking it in the popular sense as referring to immediate augmentation of property and wealth, nothing can be more false. In the latter sense, it would be in the interest of the majority in every community to despoil and enslave the minority of individuals. This is only reestablishing force as the measure of right," end quote. Public use requirement ensures that government is limited within moral boundaries. Now, of course, the problem arose in the railroad cases in which government allowed private property to be condemned by privately owned railroad companies for their own private profit. Courts handled this problem by saying that railroads were like public highways, and the government regulated the rates so as to ensure that owners did not exploit their position for monopoly profits. But at the same time that the railroad cases were simmering, there was another major crisis in American political theory, and that was the problem of slavery. Since individuals have no right to enslave a person, how can they ask the state to do so? Well, the pro-slavery answer to this was to reject the Lockean premise that the state is limited by moral considerations entirely. Some political philosophers retreated to an argument that they derived from William Blackstone, which said that the state was not limited by morality, but could do anything that was not naturally impossible. The power of the legislature, Blackstone said, was supreme, irresistible, absolute, and uncontrolled, and he explicitly rejected Locke's view that the state was limited by the same moral considerations as individuals. Now, the Civil War did not end the tension between the Lockean and the Blackstonian theories. In Stockton and Visalia Railroad versus Common Council of Stockton in 1871, the California Supreme Court took the Blackstonian view that the state was not prohibited by moral law from benefiting private parties. Quote, "The resolve of a legislative body by which private property is taken is necessarily a legislative determination that a public use is to be promoted, and this is a merely political question," end quote. Now, the dissenting Justice Joseph Crockett, pointed out that under this theory, property owners would, quote, "be wholly at the mercy of the legislature and hold their estate only by its sufferance. If the legislature should determine that it be necessary that a town or city should have a beet sugar manufactory, a wholesale clothing store, a dozen iron foundries, and several pianoforte manufactories, the people might thus be compelled to embark their estates in purely commercial enterprises, on the plea that in the opinion of the legislature, the public would derive some incidental benefits therefrom," end quote. Only a few years later, the United States Supreme Court took the Lockean view in Loan Association versus Topeka, articulating the principle that government's acts must be, as Madison said, qualified with every moral ingredient. To take property from A and give it to B, the court said, is nonetheless robbery because it is done under the forms of law. Now, with the coming of the progressive age at the turn of the 20th century, the Lockean view was outvoted. The progressives openly rejected the individualism and natural rights premises of the American founding, and instead they saw rights, including property rights, as permissions granted by the majority and revocable at will. As Louis Brandeis put it, quote, "in the interest of the public and in order to preserve the liberty and property of the great majority of the citizens of the state, rights of property and liberty of the individual must be remolded from time to time to meet the changing needs of society," end quote. Well, the progressive era, of course, saw a corresponding explosion in the use of eminent domain. A California court in 1911 said that, quote, "generally speaking, anything calculated to promote the education, the recreation, or the pleasure of the public is to be included within the legitimate domain of public purposes served by eminent domain." Public use meant whatever the legislature said it meant. They had returned to the absolutism of Blackstone. And the New Deal cases simply cashed in on this by inventing the concept of rational basis scrutiny. The recent revival of interest in the public use limitation is largely due to the several outrageous instances of eminent domain abuse recently. A 5-year study by the Institute for Justice revealed that there were some 10,000 instances in just the past 5 years of property being condemned or threatened with condemnation to benefit private interests such as Costco, IKEA, Home Depot, and Pfizer Pharmaceuticals. Donald Trump persuaded the city of Atlantic City to condemn the home of an elderly widow so he could build a limousine parking lot. Mississippi condemned 23 acres of minority-owned land to transfer to the Nissan company to build a car factory. In the Hathcock case, the Michigan Supreme Court tried to solve this problem by saying that when the selection of the land to be condemned is itself based on a public concern, government may take land to benefit private parties. Quote, "meaning that the underlying purposes for resorting to condemnation must satisfy the public use requirement," end quote. Now, this decision is a great step forward, but it contains a serious flaw. It fails to define the concept of public. Now, this is a serious problem when the question at issue is the meaning of the phrase public use. Now, while it is certainly outrageous that the ownership of land should be made contingent on the whim of the legislature, the Hathcock decision fails to solve that problem. That problem is one of political philosophy, and it cannot be solved without a direct confrontation with the political fumbles that have led to the creation of the modern regulatory welfare state. The reason so few courts are willing to seriously consider the principle that government may not take property from A and give it to B, a principle the American founders would have thought unquestionable, is because modern America is so full of redistributionary legislation which does just that courts tremble at the very thought of questioning the legitimacy of that undertaking. The primary means by which the court seeks to ignore the inevitable clash between the regulatory welfare state and the Constitution is by refusing to define legitimate state interests. For 70 years, due process and equal protection cases have been analyzed by asking whether a government action is rationally related to or is legitimately narrowly tailored to a legitimate or a compelling state interest. But in all of that time, the court has never bothered to define what a legitimate state interest is, let alone how it differs from a compelling one. It has instead focused on the degree to which a law is tailored or related to a goal, the legitimacy of which is always assumed. The court, like so many modern economists, sees itself as determining only whether a chosen legislative method is legitimate. Questioning the end is thought to be impermissible. Now, the reason is not far to seek. Defining a legitimate state interest would necessarily mean that there are some things that are not legitimate state interests, which would then raise the question of whether the government has the right to take property from those who earn it and give it to those who do not. By failing to answer the question of the legitimacy of the goals that a legislature adopts, the court is left choosing the best route to possibly illegitimate goals. Or as Leo Strauss put it, we are left with retail sanity and wholesale madness. The road ahead is blocked by a huge obstacle, a bloated regulatory welfare state that interferes with every aspect of our economic and personal lives. Those who benefit from such interference will fight hard against any attempt to return the government to its constitutional confines. But there is no alternative. Either we face that struggle, or we allow the government to continue to ignore the Constitution, including seizing private property for the benefit of private parties. Such a confrontation need not take place on the standard left-right axis. Indeed, opponents of eminent domain abuse often find themselves allied with traditional defenders of the welfare state, like Ralph Nader, who led the opposition to the condemnation of Poletown in the 1980s, and my brief in the Hathcock case was joined by the Michigan ACLU. This is because victims of eminent domain abuse are often poor minorities who do not have the political power to protect themselves from business interests. Some conservative groups, on the other hand, have felt pressure from those very business interests to remain silent about eminent domain abuse. This obstacle, too, must be overcome. As attorneys, it is not only our responsibility to litigate in defense of property rights, but to educate the public, and even our own supporters, when they are blinded by the political profits of evading the Constitution's mandates. Simply put, the regulatory welfare state is a massive unconstitutional elephant in the room which cannot be ignored if we are to restore justice to eminent domain law. We must return to the sources of the American Constitution, to the political philosophy of the Declaration of Independence, to the moral considerations which Madison said must inform every exercise of government power. Otherwise, the rule of law means nothing, and the rights of the minority will be only permissions granted by the majority and revocable at will. Thank you.
We finished on time. 2 minutes over.
I'd like to thank all of our speakers for their fine remarks. One of the highlights of the program is going to be your questions. So, if you are listening live to the webcast, please email your questions to Professor Adler, and he will relay them to us. His email address is JHA5, that's Juliet Hotel Alpha 5, at Claeys, C-A-S-E, .edu. JHA5 at Claeys, edu. Those of you who are upstairs can write your questions on 3x5 cards that are being provided, and student assistants will relay them to me. And those of you who are in the main room can be recognized, and an assistant will come over with a microphone, which we need to use for purposes of the webcast, and we'll get your question. So please prepare your questions, and while you're doing that, let me just see if we can get a little dialogue going between members of the panel. Professor Merrill was exemplary in making a very positive presentation, but in light of the comments of other panelists, I'd like to briefly invite Professor Merrill now to reveal his own views on these issues.
Do these mics work, or should I get up there?
That mic works.
We got one here.
Oh, okay. Yes, I have 3 questions that I would pose to either Professor Claeys or Mr. Sandefur, the proponents of the natural rights / libertarian view of the public use requirement in eminent domain, a position which I must confess I have found quite puzzling. And the 3 questions are as follows. First, why the hostility to economic development? It seems to me that eminent domain is all about economic development and has been from the very beginning. We use eminent domain to build highways, to construct schools, to build railroads, to build public utilities, to put in fiber optic cable. All of this is designed to promote economic development and economic growth and build make a bigger pie for people to divide up in society. If we're hostile to the use of eminent domain for economic development, what does that say about why we have eminent domain at all? And more broadly, this notion that the government is supposed to be some kind of night watchman state that only protects, the weak against the strong or protects us against predators. What about all the stuff government does all the time to try to promote economic growth and development? What about fiscal policy and monetary policy that we use to try to promote a sound economy? What about the provision of public education? What about all the infrastructural things that government does in order to try to make society more prosperous and well-off? Where do these fit into this vision? That's the first question. The second is, why the preference for the state? I find this really odd that the libertarian natural rights position accepts it as a given that the government can take property and retain title in its own name. And they even sort of grudgingly take it as a given that the government can delegate the power of eminent domain to big railroad corporations without any problem. But if the government wants to take property in order to retransfer it to other private property owners, all of a sudden that becomes unconstitutional. The effect of this position, it seems to me, would be to encourage governments to engage in redevelopment programs in which we end up with state enterprises. Instead of condemning property for a sports stadium, which a professional sports team ends up owning, we'd have municipally owned sports stadiums. And instead of having condemnation of property for Home Depot and Best Buy, owned and operated by private corporations, we'd have property owned by the municipality leased to Home Depot and Best Buy. And so I don't really see why the preference for the state in this whole thing. And lastly, the thing that puzzles me the most is that if we classify the government's powers into three categories, the power to regulate, the power to tax, and the power to take property by eminent domain, which is a somewhat conventional division of powers, why all the hostility to eminent domain? It seems to me that of the three powers, the two that are the harshest on the individual and the ones that would give rise to the greatest libertarian concern are the power to tax and the power to regulate, because when the government exercises those powers, the poor individual is left really helpless. If your money's taxed away, it's gone. If you're regulated so that your property values are depressed, too bad. If the government takes your property, you're entitled to just compensation. So it seems to me that of the three powers, in a way, the one that's the nicest to people and that acts as the greatest restraint on government, because the government has to internalize the cost of what it does through the payment of just compensation, is eminent domain. So I guess I'm left puzzled by the libertarian natural rights assault on eminent domain.
Tim Sandefur, is it true that you would prefer a City of Cleveland hardware store to Home Depot?
No, I think it's safe to say I would not be in favor of such a thing. The questions, as I understood it, was first of all, what about other welfare state programs that are run by the government? Most of those should be abolished.
Monetary and fiscal policy?
No, those I'm not enough of an expert on those to. I know that there has been some creative work by libertarian theorists on how a free market monetary system would be run. I don't know much about them myself. But as for things like public education and things like that, absolutely those should be handled by private entities. The question about why the preference for the state, I have no preference for the state that I know of. I think it's just as much of a problem when a city such as New London condemns property, or when a state does, or when the federal government does. The problem is essentially the public choice problem that everybody can make a plausible argument that their use of the property would be better than somebody else's use of the property. And if the tyrant is a big bully or a little bully, it doesn't make any difference if you're the one losing your property. So I don't really have a preference for the state. And as for eminent domain being less problematic than other things, yeah, maybe that's true. I have plenty of other problems with other things the government does. About taxation, in the olden days, taxation was subject to a sort of public use limitation in the public purpose doctrine. That was discussed best in Loan Association versus Topeka that I know of, where taxes had to be used for what Richard Epstein calls implicit in-kind compensation in eminent domain, but it was kind of the same thing when it comes to taxation, that sure, you're taxed, but in exchange for that you receive benefits that kind of average out. And on that ground, I guess that would be my argument to that. I guess that's brief.
Eric, do you think that their lack of much mention of the eminent domain power in their deliberations and in the Constitution meant that the framers agreed with Professor Merrill that this was the more benign power?
I have to be very careful with that. Tom was very good in in the part of his presentation where he said that in a lot of ways the takings clause in the federal Constitution was written as an afterthought. And that then means that a lot of the evidence you have about what was originally intended by public use limitations, it's hard to be certain what the ultimate effect is. What I'm doing in the paper and in my talk is sketching out, if you take some ideas that were influential at the time and draw out their logical conclusions for eminent domain, I sketched out what that law would look like. But you have to understand things completely. You have to balance like the penumbras of the implications from important political theory against what colonial legislatures were doing, like passing mill laws. So I can't settle that question about the original meanings and original intentions here. I'm just informing people or educating about one important piece of the puzzle.
Oh, and John, you had mentioned the imperatives of the time and the public need leading to the Poletown condemnation. Why then do you think that the court this year was so adamant in repudiating the Poletown doctrine?
Well, bad cases make bad law. Let me just say that responding to Tom's question, the attack on on economic development as it relates as a proper basis for the use of the power of eminent domain. It seems to me that that's the concern here is that is an area where the greatest abuses are occurring in the minds of a number of people, and that there needs to be some kind of a way in which those abuses can be checked. There can be a limit drawn. The Michigan Supreme Court decided that in that general arena that they would essentially exclude economic development as a proper basis for the Michigan exercise of the power in Michigan. I feel that was a great mistake, that it will be a tragedy for the city of Detroit to be able to restructure itself, and that what they should have done is they should have confirmed the economic development as a proper basis, but they should have worked on defining the heightened scrutiny test and create a different type of limitation on what was the court perceived, in my judgment, as an abuse of the power in the case of Hathcock versus Wayne County. I would have been comfortable if they had concluded that Wayne County had abused their power under Poletown and had, because what occurred after this decision was rendered is the county called a press conference and declared they were proceeding with the project because they didn't need the property in order to carry it out that they were unable to acquire through eminent domain. A total slap in the face. And I think the court was lazy in the way in which it went about attempting to preserve the right of economic development basis for the power, and in checking the inappropriate use of the power to transfer property from one private owner to another under unacceptable circumstances.
Are there a question from the audience? Wait 1 second, and we'll get someone with a microphone. Yes, sir.
Yeah, I would just like to ask perhaps Mr. Claeys and Sandefur their view on what appears to me to be the one-way street in their approach. When government acts in various ways to the detriment of the individual property owner, you feel in many instances that is a wrong that needs to be addressed. I'd like to hear your views on what happens when government action accrues to the benefit, and often the significant financial benefit, of the property owner. Various public sector investments, the construction of new roads, often dramatically increase property values through no merit or endeavor of the property owner other than sheer dumb blind luck, or perhaps in some instances insider information. The literature has addressed this. There are concepts of whether there should be givings as well as takings. And I would like to hear your view on the flip side of the state versus the individual. Thank you.
One brief comment. I am not familiar with the history of special assessments, but as I understand it, in the late 19th century, there was a quite sophisticated body of law and administrative law procedure about special assessments. Translated, that means the government lays down a road to improve city life. It pays eminent domain to the people who lose land to the roads. The primary way it raised the money to pay those people off is by imposing special assessments on the people who would benefit most from the road in proportion to the extent to which they benefited. If that was the basic or overriding object of special assessment procedures, then jurists and lawyers and policymakers who were informed by natural rights ideas 100 or 125 years ago agreed that the people who get the most gain from public action ought to pay for it.
Let me just add, there were also several state constitutions written at the time included clauses that prohibited the use of public credit for the benefit of private parties. But really the problem with government windfalls, it's unfair when somebody receives any kind of windfall, but it harms nobody, so they don't really have standing to complain unless that is being taken from them. If it's money that's being taken from me to give a windfall to somebody, that's the real problem, is who it's being taken from. These givings are as you put them, are accompanied by takings from people who have earned that money, and it's being taken from them to benefit the political insiders, and that's the real problem, is the property's being taken.
Other questions? Yes, sir.
This is, I think, for Professor Merrill. I take it that the divide on the panel is between those who would erect a kind of bright line rule that would make transfers from one private property owner to another completely out of bounds, and those who would say that such transfers might be permissible under some circumstances. This raises a kind of standard jurisprudential argument about bright lines and balancing tests, and I guess it might be useful to ask whether there might be a principled way to apply a kind of balancing test that would rule some transfers out of bounds while leaving others. And obviously, from your review of the cases, at least the state courts seem to be deferential, but not as deferential as federal courts. Is there a way that we can extract a principle from those cases, or some other principle that might help to clarify the debate for those who are uncomfortable with a bright line rule, but who are also uncomfortable with complete deference?
Right. I shouldn't. I don't want to give the impression that I'm in favor of, to use the economic terminology, cashing out every property rule and turning it into a liability rule, so that anybody's private property can be taken by anybody else based on just compensation as measured by some state tribunal. I think that would be. It would result in extraordinary injustice in terms of undercompensation to people, and it would probably be devastating to the system of property rights. On the other hand, I don't think the courts have ever succeeded in coming up with some kind of, quote, test, close quote, that identifies in abstract legal terms the circumstances in which it makes sense to use or not to use eminent domain. I think the 19th century history that I tried to trace very briefly confirms that when the state courts had this will to restrict eminent domain, and they came up with the use by the public test, exceptions began to be recognized. The jurisprudence got more and more complicated until it kind of collapsed under its own weight. My preference would be to sort of try to ration eminent domain by making it, generally speaking, a second best option to market transactions. And there are lots of ways in which we, in fact, do that. We have all sorts of due process protections for property owners in eminent domain. We have the just compensation requirement. We have relocation laws. We have the public use requirement, which I view as a kind of black box that state courts, use Ouija boards to decide what is and is not a public use. But there's a risk of invalidation, which ex ante increases the cost of using eminent domain, and therefore it serves to deter its use. And so my preference would be to enhance compensation for all people whose property is taken by eminent domain. through legislative revisions to enhance procedural protections for people whose property is taken by eminent domain, to have the state courts review obvious cases of abuse like Costco taking property from some other discounter, maybe it was 99-cent store taking Costco, or Costco taking 99 cents, I forget now. But those cases are obvious abuses, and the state courts have shown that they're ready, willing, and able to police those. And so I think we have the tools available with some tweaking to keep eminent domain from getting out of hand and posing true damage to our society. But for the judiciary to come up with a sort of limited set of ends that eminent domain can be used for and sort of impose this as a matter of federal constitutional law, I think is a project which has proven to be unworkable, and I've not heard anything from anybody proposing the revival of that approach that suggests to me that we have principles ready at hand.
Yes, sir.
For Mr. Sandifer, can you address whether the government really does have the responsibility to cure blight for the purpose of protecting adjacent homeowners' individual property interests and creating new homeownership opportunities by curing such degrading conditions?
Government has the responsibility to protect people from crime. It does not have the responsibility to alleviate blight or to increase home ownership. As a matter of nuisance, absolutely the government should prohibit one person's use of property from injuring a neighboring homeowner's use of the property. Of course, that also can be a slippery slope, and then you can have people saying, well, I don't like those people, therefore they're a nuisance, which is obviously too extreme. But to return to a position where the government simply secured people from the harm of a neighboring property use would be well within the traditional sic utere notion of property rights that I have. I do want to add one other thing to what Professor Merrill said about state jurisprudence. It's true, state courts are much more attentive to these issues, and in the article that I prepared for the CLE, which you can find on the internet site that's listed in the CLE book, I make a short argument that we need, at least in California, we need a much more serious state constitutional theory of eminent domain that would look into the experiences that occurred after the railroad cases. And a lot of state constitutional conventions were held after several decades of this railroad abuse of eminent domain, and at least in California they said that's just too much. Even railroads are not really a public use.
Yes, sir.
It seems that once we depart from the literal definition of public use, the focus then becomes about whether there are identifiable and few parties that are going to benefit, some private parties that are going to benefit in some way, as opposed to whether the public is going to benefit. The measure doesn't seem to be those sort of intangible kinds of benefits that the public surrounding the property will enjoy. Isn't it true that in a similar way that the question was asked previously, that private parties that benefit are somehow incidental or collateral to whether or not there's a significant public use or public benefit to the taking?
It depends upon, I assume, in terms of your question, it depends upon the case. And it depends upon how you view the case. If we talk about Poletown, when it was first presented to the Supreme Court in 1981, Michigan Supreme Court, it was viewed not as a case that was intended to benefit the private party to whom the property was to be transferred, but was to benefit the city and the job base and the residents who would remain there after the project was begun. If it were simply the transfer of a parcel to expand a parking lot and not create jobs and not in any way have a ripple economic development effect, it would simply be a one-on-one transfer of property. And so to me, it's very much the problem really is very much on the basis of as applied, as the power is applied, the economic effect that it would have and the benefit to the public or the benefit to the private transferee.
But parking lots do create jobs. They create jobs, first of all, for the people who make the parking lots and for the casinos that now can serve more people, right?
Well, you made it a casino case. I don't know which case we're talking about. If it's a parking lot that can't be accommodated on a particular site and will generate jobs, then perhaps it can be argued that the test should be that the public interest is served.
Okay, let's see if we could get in 2 more questions. Yes, sir.
Interested in hearing a comment about the Midkiff case and the purpose, as I understood it in Midkiff, of breaking up monopoly and land ownership and promoting home ownership. So it wasn't economic development in the sense you're talking about, but it seemed it would fit into a legitimate public purpose in most people's minds that in the unusual case of Hawaii, that you could use eminent domain, and granted it's an unusual circumstance, but in terms of the rationale, I'd be interested in hearing any comments on that.
Under the approach I sketched out, it is possible for the government to regulate monopoly and to break it up. I am not an antitrust expert, and I have not thought much about how natural law ideas influence antitrust. But I think that you could have a plausible grounds for regulating a natural monopoly like an ownership of land. You would then have to get on to do the regulatory takings analysis I sketched out right. You'd have to take account of some of these factors. First, I think there was, I forget the number. There were more than 20 landowners. I think it was on the order of 70, but it was more. The first question then is, do you have a bona fide monopoly if you're talking about 70 landowners? I'm not sure you would. Second, if the state of Hawaii and the federal government owned on the order of 45 to 50% of all the land there, is the right means to break up the concentrations of land held in private ownership when you can sell some public land off to free up the market. So there are good reasons to doubt, like even accepting that the end of breaking up the land is valid, there are questions whether there is that problem on the facts in that case, and then second, whether there's another means to do it. So I think you'd then have a taking, and you'd ask, is this a taking for public use or private use? And when the tenants get the reversion and therefore get the fee, there's been a taking for private use.
I have, you'll forgive me for being a chatterbox, but some thoughts on that. You contrast that with the way that Thomas Jefferson solved the problem of land monopoly in Virginia, which was to end the mechanism of entail and primogeniture, which did not seize property from people who earned it and give it to others. It simply made it change the rules so that the transfer of property would become wider over time. Also, James Madison addressed this issue in a brilliant essay called Sovereignty, which he wrote in the 1830s, where he explains that. I'm sorry, it's not in Sovereignty. It's in his memorandum on monopolies and ecclesiastical establishments, which he wrote in the 1830s, where he said that when monopoly or when grants of land to people are accompanied by limitations on the use of that land that require it to be used for the general public, this solves the monopoly problem, which incidentally then became one of the rationales that was used in the railroad cases that said as long as the use was regulated to ensure that the person receiving the land did not have monopoly profits out of it, that it satisfied the public use requirement. That goes to your question about givings also, I think.
There were at least 2 funny things in the Midkiff case that may have been going on in addition to this supposed oligopoly rationale. One is that my understanding of the tax law is that if you sold these lands were held by these estates that held huge chunks of land and had held it for many, many decades. If they sold them outright, they'd have huge capital gains liability, but if the property was condemned, they could roll over the condemnation award into the acquisition of other property without capital gains. So it could very well be that the statute was passed with the acquiescence of the large landowners for tax benefit purposes. The other thing is that the land was the land was rented, but the buildings were owned by the tenants. And so as these long-term leases became due, you had a classic bilateral monopoly problem with the tenant and the landlord agreeing on the renegotiation of the ground rents. And so that problem may have also fed into the need for the peculiar statute. So the stated rationale may not have had much to do with what was really going on there.
Okay, we have time for one more question if it's very brief. Sir.
With every politician promising to get improved jobs and improve prosperity and progress, how can you say that there's not an economic function for government?
Anyone want to respond?
Well,
John?
It's not. That's the whole subject here. That the government engages in a proper public purpose by trying to encourage economic development. But the question is its authority to assemble land or take land involuntarily from the the landowner circumscribed by the constitutional provision that says that you'll have to do it some other way. You simply can't compel the transfer of land because the words public use have been used. You certainly, in fact, in Hathcock, the Supreme Court ruled that the Economic Development Corporation Act, under which the county was operating, was used properly in furtherance of a public purpose. There was no violation of the act itself. The legislature had given the authority to the county to take property for and to develop property for economic development purposes by transferring to private owners. But the court concluded that while it's a proper public purpose, it's not a public use. That was their interpretation.
Don't the concepts of due process of law and law of the land indicate a strong deference to legislative judgments, as was suggested in Berman v. Parker? And I think...
Okay, we'll have to leave it at that.
I just want to add, the Goldwater Institute, you can find on their website, they have a wonderful explanation of a report on alternatives to the use of eminent domain in economic redevelopment, which essentially makes the correct constitutional point that the best thing government can do to develop the economy is get the hell out of the way.
Well, on that note, when we end this session, we will resume at 11 o'clock precisely. And before we end, I'd like to thank the audience for being here and for your excellent questions, for Case Western Law School and the Federalist Society for presenting this panel, and for our very excellent speakers.